25th day of April 2024, suit number NICN/AK/31/2017 between Awe Richard Adeoluwa and 28 others, and White Clone Limited versus First Bank Nigeria Limited. Judgment. The claimants took out an originating summons on 26 October 2017 against 3 defendants. White Clone Limited as first defendant, Insourcing Nigeria Limited was the second defendant, and First Bank Nigeria Limited was the third defendant. The suit was first heard by Adeomi Moje, who ruled on 30th April 2018, transferring the suit to the General Court list and ordered for pleadings. There is no record of what transpired from 30th April 2018, except for the petition of the claimants until 26 February 2021, when this quorum started the matter de novo and had to order for filing of the processes. Claimants filed a general form of complaint on 31st March 2021, seeking for 6 reliefs. The first defendant filed its statement of defense on 17th June 2021. The third defendant filed a notice of preliminary objection, memorandum of appearance, and statement of defense by a motion of 25th January 2022. By a motion of 30th March 2022, the claimants amended the general form of complaint. The first defendant amended his statement of defense on 6 June 2022. The claimants filed a reply to the first amended statement of defense on 17 June 2022. By a motion of 14 October 2022, the claimants discontinued their suit against the then second defendant, which is Insourcing Nigeria Limited, and amended their processes accordingly, with First Bank Nigeria Limited now as the second defendant, and prayed as follows. A declaration that the claimants are entitled to end of service benefits for over 9 years of service in the employment of the defendants in accordance with extant laws of the land and terms of employment as contained in the employees handbook. B, a declaration that the letter of disengagement or withdrawal of service issued to the claimants by the first defendant is unlawful, wrongful, illegal, and done in flagrant breach of the policies and procedure as contained in the employees handbook of Insourcing Nigeria Limited. C, an order setting aside, invalidating, and making void the withdrawal of service of the claimants by the first defendant. An order of this honorable court directing the first defendant to pay the claimants the sum of 3 million naira, each being their end of service benefits for over 9 years of service under serious banking condition with the First Bank of Nigeria Limited, third defendant, now second defendant. An order of this honorable court directing the first defendant to pay the claimants the sum of 2 million naira each as damages suffered for the wrong termination of employment cause of this action. The first defendant filed a consequential amendment on 10th January 2023, while the claimants filed a reply to it on 30th January 2023. The second defendant, First Bank of Nigeria Limited, did not file any consequential amendment. Case of the claimants is that they were employed by White Clone Nigeria Limited, and the situation continued so until the first defendant, without any reason, issued them letters of termination. Case of the first defendant is that it acquired the shares of White Clone and became the management of White Clone, and White Clone became extinct, and that it paid all the salaries of the claimants. It paid them also 1 month salary in lieu of notice and their terminal benefits. Second defendant did not call evidence but chose to rest his case on the case of the claimants. Final written addresses of the parties. Only the first defendant and claimants' counsels filed and exchanged final written addresses. Reference will be made to any written address as the need may arise in the course of this judgment. Court's decision. Having read the pleadings, both oral and documentary evidence of the parties, as well as final written address. Who is this in a car? Put off your video, and put off your mic. Having read the pleadings, both oral and documentary evidence of the parties, as well as final written addresses of counsels, I am of the considered view that the loan issue for determination is whether the claimants have proven their entitlement to all or any of the relief sought. With respect to the second defendant, I have read the entire statement of facts and relief sought by the claimants, as well as the counsel final written address. I did not see where any wrongdoing was alleged against the second defendant. There is no iota of any cause of action against the second defendant. The name of the second defendant is accordingly struck out. A starting point. Please stop talking. You don't talk. Somebody is talking. Put off your mic when you want to talk. A starting point is the pleadings of the parties. In the statement of facts, it is the case of the claimants that they were employed and confirmed by the Insourcing Nigeria Limited, and the state of affairs remained so until the first defendant unjustifiably served them letters of disengagement, Exhibit AFB 8A to G, without any reason, thus denying having any dealings with the first defendant whatsoever. The said Insourcing Nigeria Limited was the initial second defendant, but by a motion of 14th October 2022, the claimants discontinued the suit against the said Insourcing Nigeria Limited, and the then third defendant, First Bank of Nigeria, became the second defendant. Interestingly, it is the defense of the first defendant that it acquired the shares of Insourcing Nigeria Limited and became the new management, and the claimants were informed that it continued to duly pay the salaries of the claimants and when due, that it paid the claimants one-month salaries in lieu of notice and all their terminal benefits. These allegations were supported with documents tendered and admitted in evidence as exhibits AOC 31 to AOC 37. At this stage, issues are not yet joined. What was expected of the claimants was to file a reply to the statement of defense to deny these new issues raised by first defendant if they are false. The claimants filed a reply on 30 January 2023, but did not adopt them at the hearing, thus abandoning their reply. This side, Yusuf and another versus Adiwa case. 2021 LPR 56643, where the Court of Appeal held, where a witness fails to adopt his written further statement, the statement cannot be used as material in the proceedings to determine the pending matter. Them would be deemed abandoned. They cited quite a number of cases there. Where the claimant has abandoned his reply, he will be treated as if he did not file a reply, and so no issues are joined on the statement of defense. And if the defense has raised fresh facts or issues not raised by the claimant, then the claimant's failure to file a reply amounts to admission of those fresh facts or issues. See Mrs. Ifeanyi Obiozo versus Baby Namwa, 2014, LPLR 23041, where the court held, as the Supreme Court held in Unity Bank PLC versus Buhari, citation supplied, a reply is necessary where a statement of defense raises a fresh issue that was not raised or anticipated by the statement of claim. See also Agesimba versus Onuzuka, Okay. Citation supplied. Such fresh facts that have been elaborately pleaded with specific details require a specific denial in a reply. In this case, there was no denial at all as no reply was filed. Where a fresh fact is pleaded in a statement of defense, if the plaintiff does not file a reply denying such fact, then he has admitted the fresh facts as correct. The Supreme Court restated the effect of the failure by the plaintiff to file a reply where necessary in AG of Abia State and AG of the Federation. Citations supplied. Thus, having regard to the several complaints of the plaintiff, one would have expected the plaintiff to file a reply to this averment so that the defense proffered by the first defendant would at the very least be put in doubt. This the plaintiff did not do. Then the legal effect of such a failure surely is recognized as an admission of those facts pleaded by the first defendant. See also Eke and registered trustees of Travis Christian Group of Schools and another citation supplied, Cyprian and Uzo citation supplied. I have considered these averments and the documents tendered in evidence. They are believable and should be relied on. More so, none of these allegations was contradicted in cross-examination by the claimant's counsel. I accordingly believe the case of the first defendant as against the claimants. I hold that the claimant have admitted all the facts as alleged by the first defendant in the statement of defense and in the deposition of DW2. I find that A, the first defendant acquired the shares of Insourcing Nigeria Limited and that Insourcing Nigeria Limited became defunct and the first defendant became the new management and the claimants were informed of this development. See exhibit or AOC 30. B, that the first defendant continued to duly pay the salaries of the claimants as and when due. C, that the first defendant paid the claimants 1 month's salaries in lieu of notice and all their terminal benefits. Accordingly, the claims of the claimants against the first defendant fail and is hereby dismissed. For the avoidance of doubt, the claimants have failed to prove their case against the first defendant, and the claimant's case is hereby dismissed for want of merit. Each party to bear its cost. This is the judgment of the court, and it is entered accordingly.
As the court pleases, sir. My lord, we are most grateful to the well-considered ruling delivered by the court now, sir.
Any appearance for the claimant or the second defendant by now?
Yes, my lord. I'm online, my lord. Yes, my lord. My lord, good morning, my lord. I'm sorry for coming late online.
Announce your appearance.
Yes, my lord. My name is T.A. Oyolola. I announced my appearance for the claimants.
You are who?
T.A. Oyolola.
Yes, who appears for the second defendant? So, Oyolola, what do you say to the judgment?
Yes, my lord. We appreciate the industry put in writing the judgment, my lord. My lord. Anyway, my lord, we'll see what we can do after we get the copies of the judgment, my lord. However, my lord, we appreciate your lordship industry, sir.
Olaya.
My lord, we are most grateful for
Olaya.
My lord, we are most grateful for the industry, sir, and the well-considered judgment. We wish my lord more energy as he continues in service, sir.
The judgment, a copy of the judgment will be ready for collection tomorrow.
As the court pleases.
Thank you. The next judgment is Mr. Babatunde Gbenga Dada. Babatunde Gbenga Dada.
Yes, I'm present. I'm present
Please
here.
announce appearance.
May please, Your Lordship.
Announce appearance.
May please, Your Lordship, sir. My name is S.A. Olayemi. S.A. Olayemi.
Just a moment.
Yes,
It's
my
not
Lord.
written in the Zoom, so how many lines do I need? Okay. You are
S.A. Olayemi for the claimant. S.A. Olayemi for the claimant, sir.
yes, who appears for the defendants? Udofort. Or one year there. L.E. Udofort. Who appearance for defendant? This is the judgment of the court. I said this is the judgment of the court.
Your Lordship, please, sir.
As
The person concerned. The person concerned keeps quiet.
No, I am talking, sir. I say, Your
And
Lordship,
I
please.
really wonder, have we forgotten the tradition of the court? Because that was what happened the first judgment, and this one again.
I'm sorry, my Lord. I said, as Your Lordship, please, sir.
Okay.
Yes,
Suit number NICN/AD/01/2020 between Mr. Babatunde Gbenga Dada and Wema Bank PLC. The claimant took out a general form of complaint against the defendant on 29 January 2020, seeking for 5 reliefs. By a motion of 16 September 2020, the defendant entered appearance and a statement of defense. The claimant filed a reply on 26 January 2020. By a motion of 25th October 2021, the claimant amended his complaint and statement of facts and filed fresh copies on 1st November 2021. The claimant prays for the following: a declaration that the suspension and the subsequent termination of the employment of the claimant from the service of the defendant, where is later dated the 1st March 2017, contrary to his terms of employment and without any valid, cogent, and verifiable reasons, constitutes a blatant and flagrant violation of the claimant's rights as enshrined in sections 34(1), 36(4), 5, and 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and the African Charter on Human and People's Rights Ratification Enforcement. B, a declaration that the suspension and subsequent termination of the employment of the claimant from service of defendants, where it's later dated 1st March 2017, contrary to his terms of employment and without any valid, cogent, verifiable reasons, is a violation. This prayer is the same thing with prayer A, except for the addition of and is therefore illegal, wrongful, unlawful, null and void, and of no effect. Otherwise, prayer A and B are just the same. C, an order of this honorable court reinstating the claimant as an employee of the defendant with all his entitlements, including his salary arrears since 1st March 2017 till date, and other allowances accruable to the claimant from the defendant forthwith. Or in the alternative, that's alternative to C, an order of this honorable court directing the defendant to immediately pay the claimant his outstanding entitlements between February 2016 and February 2017, which amounted as this court may deem fit to make in the circumstances. Case of the claimant, he was employed by a defendant in 2009 and he worked till 2017 when his employment was terminated on allegation of loan fraud against the claimant. He personally calculated his entitlements to be 2,252,611. That is entitlement calculated between 2016 and February 2017 is 2,505,204.25. That is our emoluments minus his total indebtedness is 2,505,204 minus 15154 equals 2,352,611. That the defendant is still owing him outstanding entitlement of 2,352,666 being entitlement between February 2016 and March 2017 yet to be paid to him. That up to now the defendant has not paid him his outstanding salary between March 2016 and February 2017. Case of the defendant. The defendant denied all the assertions of the claimant. It also joined issues on the loan fraud, joined issues with the claimant on the loan fraud. And stated also that the claimant is not entitled to salary or pay for the period of his suspension, and that is in line with Article 9.9.1, 9.9.2, and 9.9.3 of the Human Capital Management Policy Manual of the defendant. Final written addresses. The defendant submitted his final written addresses. The summary of the address is set out here. Part of the contention is that where to look for that when an inquiry is on the reason for termination of employment, the place to look for such reason is the letter of termination and not what is alleged to be the reason. And also that by its human policy, it is allowed to suspend without salaries. There are some other submissions there. The claimant submitted his final written address, submitted that his employment enjoys statutory flavor, and that the defendant did not follow the human capital document in terminating his employment or in the suspension. Court's decision. Having considered the pleadings, evidence, and written submissions of both counsels, it is the view of the court that the long issue for determination is whether the claimant has proven his entitlement to all or any of the reliefs claimed. In doing so, we shall ask and answer the following questions. 1, whether the claimant's employment was terminated for any stated reason. 2, whether the employment of the claimant enjoys statutory protection. 3, whether the claimant is entitled to salary during the period of suspension. 4, whether the claimant is entitled to damages as claimed. Question 1, whether the claimant's employment was terminated for any stated reason. Both the claimant and defendant in their pleadings made it appear as if the claimant's employment was terminated as a punishment for the allegation of loan fraud. The defendant counsel, however, made a U-turn in his final written address when he submitted that the claimant's employment was simply terminated in line with the contract of employment. I have read exhibits GBD3 and GBD4 termination letter and the promised communication in GBD3. The termination of payment letter reads as follows. In line with the terms of your contract agreement with the bank, management has decided to terminate your appointment from the services of the bank with effect from March 1st, 2017. You should surrender the entire bank property in your possession, including your staff identity card, to your business development manager. Please note that your entitlements or indebtedness will be communicated to you in due course. Exhibit GBD4 is the communication of the claimant's entitlements of indebtedness. Under the heading entitlement is in the table are 1, gratuity, 2, salary, February 2016, 3, salary in lieu of notice, 4, 13th month salary. Once the reason for termination is not stated in the letter of termination, no reason can be written into the termination letter by the employee claimant or defendant employer after the employee has sued in court. It does not matter that the reason existed in fact and that the termination was actuated by that reason. Once the matter is before the court, the place to look for the reason for termination is the termination letter CEOHA and Mobile Producing Nigeria Unlimited 2011 LPLR 4477, where the court held thus. Learned counsel for the respondent submitted that the lower court was right when it held that in considering the issue whether the termination of the appointment of the appellant was right or wrong, the court must confine itself to the letter terminating the appointment and not go outside it to look for other reasons which the appellant thinks or suspects may have been behind the termination. This represents the correct position of the law. It is settled that where no other reason is stated for the determination of appellant appointment except the appellant's service were no longer required, the court cannot go outside the said letter to discover the reasons for the termination. See Chukuma and Shell Petroleum Development Company Limited, citation supplied, CBN versus Amica, citation supplied, Cato versus CPN Supra. From the content of the termination letter, the claimant is not entitled to adduce any reason he suspects is behind his termination. See Cato versus CBN, 1999, 6 Nigeria Willy Law Report, Part 507, page 390 at 408, where the Supreme Court, per Belgore JSC, as it then was stated. The letter of termination of the respondent's appointment simply stated that his services were no longer needed and he was advised to collect his 1 month salary in lieu of notice as provided for in Class 2 of Exhibit 7, Staff Manual. The Staff Manual, Exhibit 7, is the document regulating the contract of employment of the plaintiff with the defendant, and Class 2 thereof is the binding clause. The letter of termination never adverted to any fraud, misconduct, or dishonesty, and the respondent cannot read into his termination letter what is not contained therein. It is also clear that the argument of the defendant that the termination was for misconduct does not flow from the content of the termination letter, but from what the defendant's counsel thinks or imagines could have been the reason. This is not permissible by law. CEOHA and Mobile Producing Nigeria Limited, cited by the defendant's counsel. I find, therefore, that the claimant's employment was terminated for no other reason than in line with the terms of his contract agreement with the defendant. Question 2, whether the employment of the claimant enjoys statutory protection. The claimant prays in reliefs A, B, and C as follows. A and B, which are the same, I just reproduce B. A declaration that the suspension and the subsequent termination of the employment of the claimant from the service of the defendant via its letter dated 1st March 2017, contrary to his terms of employment and without any valid, cogent, and verifying reasons, is a violation of the claimant's rights as enshrined in Section 34(1), 36(4), 5, and 6 of the Constitution of Federal Republic of Nigeria 1999 as amended, and the African Charter on Human and People's Rights, Ratification and Enforcement Act, A9 laws of the Federation of Nigeria, and is therefore illegal, wrongful, unlawful, null and void, and of no effect. An order of this honorable court reinstating the claimant as an employee of the defendant with all his entitlements, including his salary arrears, since 1st March 2017 till date, and other allowances accruable to the claimant from the defendant forthwith. The claimant further pleads in his paragraph 27 that the employment enjoys statutory flavor. It is also the submission of the Learned Claimant Council that it has been established through evidence before your lordship that the claimant's employment with the defendant is statutory as to bind the defendant to comply with the condition of service. The claimant has produced the letter of probationary employment dated 1st October 2009, Exhibit BGD1, and letter of permanent employment dated 24th November 2011, Exhibit BGD9. But while fully aware that an employer defendant can terminate the employment of the claimant as a servant, cannot be imposed on an unwilling master, we submit that what is essential is that the termination of employment must be done in accordance with the terms and conditions of the employment and must follow fair hearing principle. He also cited some cases there. The above prayers are normally granted in an employment with statutory flavor, but in a master-servant relationship, termination of employment can only be declared wrongful, for which remedy is damages. An employment enjoys statutory flavor when the contract of service is governed by statute or where the conditions of service are contained in regulations derived from statutory provisions. See Imolame and WAEC, citation supplied. Olaniyan versus University of Lagos, citation supplied. Chitabe versus Public Service Commission, citation supplied. In Idoniboye Obu versus NNPC, citation supplied. The court per JS is stated thus: two of the vital ingredients that must coexist before a contract of employment may be said to import statutory flavor include the following. 1, the employer must be a body set up by a statute. 2, the stabilizing statute must make express provisions regulating the employment of the staff of the category of the employee concerned, especially in matters of discipline. The claimant has not shown any evidence of the above elements in the employment between him and the defendant. The fact that the claimant has produced the letter of probationary employment dated 1st October 2009 and letter of permanent employment does not prove employment with statutory flavor. The claimant counsel was right on. The claimant counsel was rather right. Sorry, the claimant counsel was rather on the right track in his second paragraph, which is rather a U-turn, that while fully aware that an employer defendant can terminate the employment of the claimant as a servant cannot be imposed on an unwilling master. We submit that what is essential is the determination of employment must be done in accordance with the terms and conditions of the employment and must follow fair hearing principle. There is accordingly no material before the court to hold that the employment of the claimant with the defendant enjoys statutory protection. I decline to make any such declaration. Furthermore, prayers 1 and 2, a repetition, are badly drafted. Counsel already assumes, or rather adjudged, that the suspension and termination were contrary to claimant's terms of employment. The relief did not pray the court to make a declaration that the suspension and termination were contrary to claimant's terms of employment. Little wonder, I have painstakingly looked for the allegation of facts from the claimant averments which make the suspension and termination unlawful or illegal, in which case the suspension or termination can be declared wrongful. I did not see. Accordingly, reliefs A, B, and C fell and are hereby dismissed. I can't hear counsel respond.
As places, my lord.
So we don't know whether you are still listening or not.
We are still listening. We are following your lordship.
Question 3, whether the claimant is entitled to salaries during the period of suspension. The claimant pleaded as follows, that up to now, the defendant has not paid him his outstanding salary between March 2016 and February 2017, and that his salaries between March 2016 and February 2017 is 2,505,204.25 kobo. By Exhibit BGD2, the claimant therein admitted that he had been on suspension since February 2016 pending investigation. In the defense, the defendant ascribed that period to a period of suspension and pleaded that the claimant is not entitled to salaries or any pay during the period of suspension. The claimant was never absolved and reinstated from his suspension. In EcoBank Nigeria Limited versus Idemudia 2023 LPLR 61505, the court held as follows. The right of an employer to suspend an employee is not at large. It must be done within the ambit of the law. In the case of NS versus First Consultant Medical Center Limited, citation supplied there, the court held. In Mobile Producing Nigeria Unlimited and another, it was held. In the instant case, there is no evidence before the trial court that there were any laid down conditions between the parties stating clearly the right of the first appellant to suspend the respondent without pay. The first appellant did not tender through DW2 any document embodying such condition of service. What it amounts to is that the first appellant did not possess the right under the said contract of employment to suspend the respondent indefinitely without pay. In Global Motors Holdings Limited versus Oyewole, citation supplied, the court held as follows. Pending his recall or dismissal, a suspended employee is entitled to his wages or salary during the period of suspension, unless the terms of contract of employment or the letter of suspension itself is specific that the respondent employer will not be paid salaries during the period of suspension. See also Aloysius was Diamond Bank PLC, where this court held the law is that an employer cannot suspend its employee indefinitely and without pay if such is not expressly stated but in the parties' terms and conditions of employment. Specifically, paragraphs 9.9.1 and 9.9.2 of the Defendant's Human Capital Management Policy Manual state thus, and I quote, 9.9.1, where a staff is suspended for major misconduct, e.g. fraud cases, he or she may be suspended from work until the case has been fully investigated and decided upon. All cases of suspension shall be quickly attended to, and the affected staff shall not be entitled to his or her pay during the period. 9.9.2, HCM may suspend any staff without pay pending completion of the investigation/inquiry. However, the suspension period must not exceed 6 months before determination of the case. In Udegunam versus FCDA 2003 citations applied, the court held as follows. An employer has discretion to give a lesser punishment to an employee, but it has no discretion to give a higher punishment than that prescribed. I agree totally with the submission of claimant's counsel when he submitted that the claimant was suspended for 12 months, 19 February 2016 to 1st March 2017. This is contrary to paragraph 9.9.2 of the Defendant's Human Capital Management Manual, which states that such suspension must not exceed 6 months before determination of the case. By paragraph 9.9.2 of the Defendant's Human Capital Management Manual, the agreed terms is that the right of the defendant to suspend without pay is limited to 6 months. Any suspension beyond 6 months, the employee will be entitled to his salary after the first 6 months. The claimant is accordingly entitled to 6 months' salary for the extra 6 months that he was on suspension without pay, as it violates paragraph 9.9.2 of the Defendant's Human Capital Management Manual. For this reason, the alternative relief to relief C succeeds in part in that the defendant ought to pay the claimant 6 months' salaries, which is half of 2,350,000, amounting to 1,175,133 naira 5 kobo. 4. Whether the claimant is entitled to damages as claimed. Damages are not awarded as a matter of course. In the circumstance of this case, having held that the termination of employment was in line with the terms of the contract of employment, and having awarded to the claimant 6 months' salaries for the period of suspension without pay beyond the allowed initial 6 months, there is no basis for any award of further damages, and I so hold.
Scott basis.
For the avoidance of doubts, the case of the claimant succeeds in part, and it is hereby ordered as follows. 1. That the defendant is to pay to the claimant 1,175,133 naira 5 kobo, being 6 months' salaries during the period of suspension. 2. The amount is to be paid within 30 days of this judgment, or the amount shall attract 10% interest per annum. This is the judgment of the court, and it is entered accordingly.
Scott basis. Lord, we thank your Lordship for the erudite judgment, sir. May Lord continue to be with your
Is that Olayemi?
That's Olayemi, sir. Yes, Olayemi.
Yes, is Udoford online now?
My Lord?
Is L.E. Udoford online now? No. Thank you. Off your mute. All right.
Carry my bag and everything. Just carry them. We will look for a place.
AK 29 2021, AK 39 2021, Mrs. Florence Washola Bello and Mr. Adebayo Adeshida.
I don't know how we are going to. We'll do it then.
Are you sure? Maybe. Okay. Good. I've seen it. Afolabi. Afolabi. Musa.
Yes, my lord.
Abba, Musa. They call your case. You will not respond until we call your name.
Sorry, my lord.
Please announce your appearance.
May it please this honorable court.
Announce your appearance.
May it please
Yes.
this honorable court. I am AI Musa.
Yes.
AI Musa for the defendant, my lord. Defendant applicant.
What is your application?
Yes, my lord. My application is for an order of this honorable court granting leave to the defendant, my lord, to recall DW1. Mr. Adebayo Adeshida, sir.
Yes.
Yes, my lord. My lord, the application is dated the 26th day of March, 2024, sir.
Hello, my lord. My name is Iyola Polabi. And with me is JG Sam for the claimant.
With who?
JG Sam SAM.
Yes, Musa.
Yes,
We
my
have
lord.
a motion dated 26 March 2024 and
Yes,
filed
my lord. On 27th March 2024, my lord.
27 March seeking
My lord, I am seeking for an order of
for an
this court
order for the
of
defendant
honorable for granting leave to the defendant.
to reopen his case.
Yes, my lord, recalling DW1.
To recall DW1.
Yes, my lord.
To tender
The receipt of Pisamot stock.
a receipt, or is it receipt?
Of Pisamot stock.
To tender receipt in evidence.
Yes, my lord.
Yes, Iyola. Have you
My
been
Lord, we are
served?
opposing the application. Yes.
I asked a different question and you are answering a different thing.
As the
Yes,
court
we
I
were
please.
said,
served,
have
my
you
Lord.
been served?
We were served.
Are you opposing?
Yes, my Lord.
Are you opposing?
We are opposing the application, my Lord.
Did you file a counter affidavit?
Yes, we filed a counter affidavit.
Did you file a counter?
Yes, we did, my Lord.
How many paragraph counter affidavit?
Where's the thing you filed?
What's the 10th paragraph counter
Sorry, just a
affidavit
minute, my Lord.
on 19th April 20? Is your
It's a
case? You don't have the processes in front of you.
I do, my Lord. It's a 10th paragraph affidavit of 19th April 2024.
Okay. Yes. Yes, are we ready? Are we ready
Yes,
for
we are
the
ready, my
motion?
Lord.
Yes, my lord.
Okay,
Yes,
Musa,
my
move
lord.
your motion.
Yes, my lord. My lord,
You have already introduced the motion. Let's go to the affidavit.
yes, my lord.
Our motion is supported
My lord
by
is supported by 12 paragraph affidavit, sir. 12 paragraph affidavit, sir.
a written
And a written address, sir.
address.
Yes, my lord.
What about how many annexures?
My lord, we have
How many
four.
annexures?
Four, my lord. Four, my lord.
Eh?
4 annexures, my lord. Four.
Those are the receipts intended to be tendered,
Yes, my lord. They are
right?
the. Yes, my lord. Very well, my lord.
The 4 annexures are marked what?
My lord, exhibit A1, A2, A3, and A4, sir.
A1, 2. Annexures A1 to A4. They are the receipts intended to be tendered, right?
Yes, my lord. Very well, my lord.
Okay. Yes, you adopt. Continue.
Yes, my lord. My lord,
Continue.
they said affidavit is deposed by one Oyekule Olusola Eniola, my lord.
We
The
have
secretary.
passed that now. We have passed that. Please
My lord,
adopt.
we seek to adopt, my lord, the said written address, my lord, as our argument in this matter, and we urge your lordship to grant our application in the interest of justice, sir.
Yes, the crux of your affidavit.
Sir?
The crux of your affidavit.
Yes, yes, my lord, it is we rely on all the environment, sir, particularly paragraph 8, sir.
What is the crux of the affidavit?
Sir? My lord? My lord?
I say, what is the crux of your affidavit?
My lord, the clause is for it is up, my lord is in the support of the said motion, sir.
Yola,
Yes, my lord.
your turn.
In opposition to the motion, we
We
filed
filed
a
a 10
10-paragraph
paragraph
affidavit
affidavit
on the
on the
19th day
19th
of
day of
April
April
2024.
2024.
We rely
We
on all
rely
the
on all the
acknowledgments
agreements
of the
of the
affidavit
affidavit
sworn to
sworn
by
to by
Mayowa
Mayowa,
Omojola, a legal
legal
practitioner in our law
practitioner in our
firm.
law.
Yes,
Also,
yes,
we
Also, we
filed a
filed
written
a written
address
address
in line with the
in
rules
line
of
with
this
the rules of
honorable
this
court,
honorable court,
and we
and
adopt
we
same
adopt
as our
same
argument
as our argument
in
in
opposition to
opposition
the grant of
to
that
the grant
motion,
of that motion,
and urge the
and
court
urge the court
to throw out
to
that
throw out
motion
that motion
as a ploy
as a
to
ploy
delay
to
this matter.
delay this matter.
We've
We've
concluded hearing
concluded
over a
hearing
year,
over a year, and
we are still on the
we
same
are still on
spot
the same spot.
because of frivolous reasons, even for the
what is the crux of your
for the error of the
opposition?
claimant, I mean of the defendant. So we urge the court to
What is the
dismiss the
crux of
application.
your counter affidavit in opposition?
My position is that this document has always been, they've always been with them, and they refuse to tender it during trial. They can't have a second bite at the cherry, my lord. Just because the claimant admitted owing during cross-examination shouldn't be an excuse for the defendant to start delaying the matter. So we feel
right.
that
Is that all?
the application is brought to deliberately frustrate judgment in this matter.
I have looked at the affidavit in support of this application, and in paragraphs 4 to 9 of the affidavit, and in particular paragraphs 4 to 9 of the affidavit, I am satisfied that since the defendants have pleaded and front-loaded, and since the documents were pleaded and front-loaded, and the defendant omitted to tender same, it is just and in the interest of justice to allow to reopen his case so that the omitted documents can be tendered. I find merit in this application. Same is granted as read.
As a couple.
Yes, date for hearing. Is 21st May okay?
Yes, my lord.
21st May.
Yes, my lord. It's okay. It's convenient, sir.
I'm sorry. 21st May is convenient, sir.
Yes, my lord. It is convenient.
Case adjourned to 21st May 2024 for continuation of defense.
As the court places. I agree, sir.
Okay, that is the end of the Zoom proceedings for today. We shall all leave.
As a God pleases.